I want to talk about this poem that I just read recently. Somebody sent me this poem. It's a poem by a Polish poet, Szymborska. I'm not going to try to pronounce her first name. She won the Nobel Prize a few years ago. And the poem is called The End and the Beginning. And in this poem, Szymborska writes about rebuilding after a war. And she says, after every war, someone has to clean up. Things won't straighten themselves up after all. And she writes that somebody has to shove the rubble to the roadside, and that somebody has to trudge through sludge and ashes, through the sofa springs, the shards of glass, the bloody rags. It takes years, she says. And she would know because she was 22 when the Second World War ended. And she didn't write the poem until about 50 years later, so she knew what it had taken to rebuild Poland. Over the last 8 years, Americans haven't been through anything nearly as destructive as the war that Szymborska experienced. And I think it's a question whether the Bush administration's war on terror should be called a war at all, except insofar as it encompasses the wars in Afghanistan and Iraq. And at least inside the United States, the only place you can go to see the kind of physical devastation that ordinarily follows a war is Ground Zero in New York. That's the only place you can go to see that kind of physical devastation that Szymborska must have seen all around her after the Second World War, and that Iraqis and Afghans must see all around them today. But over the last 8 years, terrorism and the war against it have wrought a different kind of destruction inside the United States. And this is because the Bush administration's war on terror involved not only the deployment of military troops abroad, but also a kind of intellectual project, a complete rejection of the legal framework that has constrained executive power inside the United States since the founding, and a complete rejection of the human rights framework that has restrained state power since the Second World War. That intellectual project, I think, has left a kind of devastation. It's not the same kind of devastation that's ordinarily left by bullets and bombs and shells, but it's nonetheless a kind of devastation. The Bush administration's lawyers worked mainly behind closed doors, but the policies that were built on their work, I think, are now well known. Inside the United States, the administration rounded up hundreds of immigrants, and it held them without access to counsel for months and in some cases years. It singled out Muslim immigrants for special registration requirements. It inaugurated a warrantless wiretapping program that violated not just the Constitution, but also a statute that had been on the books for almost 30 years. It declared U.S. citizens to be enemy combatants and asserted the authority to hold them indefinitely without trial. And it seized the property of all of the largest Muslim charities, and it argued successfully that donors to those charities could be held criminally responsible, could be criminally prosecuted, whether or not they had knowledge that their money was going to support terrorism. Beyond the nation's borders, I think that the Bush administration's policies were equally objectionable. They authorized the CIA to set up secret prisons all over the world into which an untold number of people were disappeared. The administration authorized interrogators to use methods that were once prosecuted by the U.S. as war crimes. It transferred prisoners to the custody of foreign nations that are known and expected to use torture. And at Guantanamo, it detained hundreds of men in what was effectively a legal black hole. And it denied them access not just to lawyers, but to the courts as well. So the human rights framework that the United States helped to construct has essentially been raised. And the same is true of the constitutional framework that the founders intended to constrain executive power. To survey the legal landscape today is to look on a world that has, in a very real sense, been devastated by war. And to rebuild the human rights framework that the Bush administration destroyed will take years, as rebuilding after a war always does. Szymborska, the Polish poet, she writes, "The bridges need to be rebuilt, the railroad stations too. Sleeves will go ragged from rolling them up." For us, I think rebuilding will require undoing the policies that the Bush administration introduced. But it will also require unraveling the fears that are now second nature to us, the arguments that we no longer subject to examination, and the assumptions that we don't question. And in fact, it may be that the most persistent legacy of the Bush administration will not be any specific policy, but rather a specific proposition. The proposition that liberty and security are values to be traded off against one another. That liberty necessarily comes at the cost of security, and that security comes at the cost of liberty. That proposition, and I'll call it the tradeoff thesis because that's the name it goes by in legal academia, that tradeoff thesis has been widely accepted. To many people, it's just common sense. And the tradeoff thesis has undergirded many of the debates that have occupied Americans for the last 8 years. That's true, for example, of the debate around torture and also the debate about warrantless wiretapping. After the US Supreme Court ruled in 2004 that Guantanamo was not beyond the reach of the courts, the New York Times congratulated the Supreme Court, and it said that the court had, quote, struck the right balance between security and liberty. And the theory that security and liberty must be balanced against one another, that the two are competing goods, isn't propounded only by newspaper editorials. Some of you may have read Michael Ignatieff's book. It's called The Lesser Evil. And that book argues, among other things, that governments should be able to, quote, suspend human rights in times of emergency. He says, human rights are not a system of indivisible absolutes. Their application requires balancing liberty and necessity. So obviously there's an element of truth in that. As a descriptive matter, policies defended in the name of national security often require us to surrender some of our rights. But the relationship between liberty and security is more complicated than that trade-off thesis allows. For one thing, policies introduced in the name of security sometimes cost us not only liberty, but security as well. And I think that's true of the prison at Guantanamo, because that was inaugurated in the name of security, but it's alienated some of America's allies, and it's become a recruiting tool for terrorist organizations. The CIA's torture program, too, was inaugurated in the name of security, and it's had similar consequences. And though the Bush administration insisted that the warrantless wiretapping program was necessary to protect the nation against attack, they offered no evidence that the program actually yielded intelligence information that would have been lost had the program not been started in the first place. In other words, they offered no evidence that the surrender of our privacy rights resulted in any corresponding increase in security. But I think that there's a deeper problem with the trade-off thesis. If we take the trade-off thesis seriously, then we would have to conclude that the most secure societies are the least free. We might even come to the conclusion, as Michael Ignatieff does in his book, that democracies may need to become dictatorships in times of crisis, and that some form of dictatorship may be acceptable, a lesser evil, he says, if it's temporary. But I think it's a mistake to conceive of democratic freedoms as a luxury to be surrendered during times of national security crisis. We should value those freedoms not only in themselves, but because they lead to more informed citizens, more accountable leaders, and ultimately to better public policy. Democratic freedoms are more important, not less, during times of crisis, because during times of crisis the stakes are higher, and accordingly it's much more important that we get the answers to the hard questions right. The US has obviously grappled before with the relationship between liberty and security. It's not new to the war on terror. And the perceived tension between the two values, liberty and security, is a recurring theme in the Supreme Court's jurisprudence. Many of you will be familiar with the 1971 Pentagon Papers case. In 1967, Robert McNamara, who was the Secretary of Defense at the time, commissioned the Pentagon Papers, which were essentially a history of the of the war in Vietnam. And in June of 1971, a former Marine who had worked on that history leaked the Pentagon Papers to the New York Times and the Washington Post. And those newspapers began to publish stories based on that secret history. The White House went to court, and it asked the court for an injunction against publication. And the district court, the lower court, saying to the New York Times and the Washington Post, you can't publish this stuff anymore. And the Supreme Court was asked to assess the constitutionality of that prior restraint. And it was asked to do that at an extraordinarily difficult time in American history. Over the preceding year, President Nixon had stunned Americans by announcing that the United States and South Vietnamese forces had invaded Cambodia. And National Guardsmen had shot and killed university students who were protesting at Kent State University in Ohio. And Lieutenant General William Calley had been convicted for his role in the massacre of dozens of civilians at My Lai. And total American deaths in Vietnam at that time had surpassed 45,000. So it was a very difficult time at which the court was asked to make this decision about whether the Washington Post and the New York Times could continue to publish the Pentagon Papers, or stories based on the Pentagon Papers. And in its legal briefs, the United States argued that publication of the Pentagon Papers would lengthen the war, would endanger American intelligence operatives working in Southeast Asia, and would broadcast nuclear secrets to hostile countries. So, despite tremendous political pressure, the Supreme Court rejected the White House's arguments, holding that the government's interest in protecting sensitive information, even classified information, could not justify a prior restraint against the press. And this is how Justice Hugo Black explained his reasoning. The guarding of military and diplomatic secrets at the expense of informed representative government provides no real security for our republic. The drafters of the Constitution sought to give this new society strength and security by providing that freedom of the press, religion, and assembly should not be abridged. And Justice William Douglas agreed, and he said that the newspapers could not be enjoined from publishing classified papers, and he saw the issue in similar terms, and he wrote, quote, "Secrecy in government is fundamentally anti-democratic. Open debate and discussion of public issues are vital to our national health. On public questions, there should be uninhibited, robust, and wide-open debate." So in the Pentagon Papers case, the Supreme Court didn't see government transparency and democratic freedom as things to be traded off or surrendered in times of national security crisis. They saw these things not as threats to national security, but as guarantors of national security. And that argument sounds almost radical today. Over the last 8 years, the Bush administration has insisted on unprecedented secrecy about government conduct, contending that this secrecy is integral to our security, that openness and transparency would put the country at risk. And on that theory, the administration defended secret arrests, secret detention, secret prisons, secret legal filings, secret evidence in criminal trials, and secret hearings in immigration cases. And it's clear, to me at least, that this systemic secrecy has led to a less informed public, and I think it's clear that it's also led to bad policy. Who knows what harm might have been avoided, for example, if the Bush administration's torture memos had been released to the public and subjected to public scrutiny and debate when they were written in 2002. We might have avoided the Ghraib scandal at least. Excessive secrecy has also made it difficult to hold government officials accountable for their decisions. The Bush administration argued successfully that every case involving the CIA's rendition program had to be dismissed on so-called state secrets grounds, that none of the cases could be litigated without the impermissible disclosure of classified information. One of my clients is a guy called Khalid al-Masri. He's a German citizen who was abducted by the CIA in Macedonia, taken to Afghanistan, brutally interrogated there for almost 5 months. And then after the CIA determined that it had arrested the wrong guy, dumped unceremoniously in a field in Albania. Al-Masri's story has been corroborated by German prosecutors and by the Council of Europe. His story has received attention in newspapers around the world. And when we filed a lawsuit against the CIA, everything we alleged had already been confirmed by multiple sources, including by governments allied to the United States. And yet, when we got to court, the Bush administration's lawyers argued that the state secrets doctrine foreclosed government officials from being held to account for the crimes that we had alleged. In the end and the beginning, Szymborska writes that rebuilding after a war can be difficult because there are no sound bites, no photo opportunities, and, quote, all the cameras have gone on to other wars. Now, the strange thing about the War on Terror is that, in a sense, the cameras were never there in the first place. So much took place behind closed doors. And even the things we now know for a fact are things that haven't been officially confirmed or acknowledged. Everyone knows that Khalid al-Masri was the victim of the CIA's rendition and torture program. The Germans know it, the Council of Europe knows it, the New York Times knows it. The only place we can't talk about it is in a US courtroom. In one of the most important judicial opinions relating to the War on Terror, Judge Damon Keith wrote that democracy dies behind closed doors. And that sentence, I think, captures something that we managed to forget over the last 8 years. It's not only the CIA's torture program that has been made off limits to the courts for reasons of national security. We ran into a similar problem when we sued the National Security Agency over the President's warrantless wiretapping program. As many of you will remember, in December 2005, President Bush acknowledged that 4 years earlier he'd authorized the NSA, the National Security Agency, to inaugurate a program of warrantless surveillance inside the nation's borders. According to the Attorney General, the program included the interception of US citizens' international telephone calls and emails whenever the NSA concluded that there was a reasonable basis to believe that one party to the phone call or to the email was associated with a terrorist group. Now, the controversial aspect of the program was not, of course, that it involved the interception of those particular communications. Everybody agrees that the government has an interest in surveilling the communications of suspected terrorists. The controversial aspect of the program was that it involved the interception of these communications without judicial oversight that was required, not just by a federal statute, but also by the Fourth Amendment to the Constitution. When we filed suit, there was little about the warrantless wiretapping program that was secret. The New York Times had reported the program's existence and provided details about its scope, and then the President himself had confirmed virtually everything that the New York Times had reported. In court, though, the government's attorneys took the position that despite all of the information about the program that had been made public, the case couldn't be litigated without the disclosure of state secrets. Now, the Bush administration, I think, used secrecy repeatedly to shield its own officials from accountability for their decisions. Amongst legal scholars, virtually no one argues anymore that the warrantless wiretapping program was anything but unconstitutional. Virtually no one argues that the torture program was consistent with the Geneva Conventions or with the War Crimes Act. And yet no official has been held to account, civilly or criminally, for those programs. Since he took office, President Obama has been revisiting some of the Bush administration's signature policies. Within 24 hours of taking office, President Obama issued executive orders that banned torture, shut down the CIA's secret prison system, and committed to closing Guantanamo within a year. Now, I think that President Obama deserves credit for making those decisions. They're hard decisions, but in the end, they will serve both liberty and security. I think it's fair to say that President Obama has begun, though only just begun, what will be the long process of rebuilding. But rebuilding will require more than undoing the Bush administration's policies. Over the last 8 years, we've come to accept too readily that our democratic freedoms must be surrendered in the name of national security. Our acceptance of that argument has led to public ignorance about government policy, to government officials who operate in a climate of impunity, and to public policy that serves neither liberty nor security. Many of the things that were supposed to have made us more secure have made us less secure instead. And in the process, they have made us less free as well. One of the best lines, I think, in this Szymborska poem is the one that I'm going to leave you with. And her line is, "Things don't fix themselves after all." And I think that that's something that we should all keep in mind as we start this new era under a new administration. Thanks. Sure, yeah, if there are questions, I'm happy to take them. Yeah.
As someone who's obviously got a vested interest in human rights and someone who studies the law, how do you on a personal level go about your day knowing that the deck is somewhat stacked against you with legal doctrines like the state secrets privilege?
You know, I think working at the ACLU, most lawyers who work at the ACLU, I think, don't think of themselves solely as lawyers, as litigators. They think of themselves as advocates, and law is one tool we use to advocate a pro-civil liberties, pro-human rights position. And so with some of these state secrets cases, we kind of knew going in that winning in court was going to be very difficult. I think that in most places around the country now, to win a state secrets case, you're going to have to get a court to reconsider its own precedents, which is always a very, very difficult thing. But sometimes we bring these cases in part because they help us tell a story. And I think the Khalid al-Masri case, which I mentioned, is a good example of that. I mean, we did hope to win that case. We didn't. But we also brought the case because we thought that telling the story provided a form of justice to our clients and served as a means of raising public awareness about an issue that we thought people should know about and be thinking about. And I think on those two counts, we had more success. There have been a number of editorials in major newspapers around the country. He's testified by a video hookup before Congress. While he hasn't received an apology, let alone, he hasn't received compensation, let alone an apology for what he went through, there's now legislation before Congress that was introduced by Senator Kennedy that would actually reform the state secrets privilege. So I think that, even in cases where we have a strong suspicion that we will lose in court, sometimes we can win outside court if we do things right. Yes?
I have two things I'd like to discuss. One is, one is like the recently getting rid of illegally immigrants. Was this due to the 9/11 connected to the terrorist threat? And the other part was, what is the ACLU going to do, or what is your program for solving the illegal immigration? What do you do to protect illegals and illegal people, illegal Hispanics from being brought to court and separated families, etc.?
Well, I guess the first thing I should say is that I'm not an immigration lawyer, and we have a whole team at the ACLU that works solely on those issues. So my answers to your question are going to be somewhat less informed than they should be. But I'll tell you one thing we've been. So I think that one of the things that the ACLU has been focused on is we have a very small team of lawyers that works on immigration issues, and they have to pick and choose their issues very carefully because they don't have that many resources. One of the things that they've been very concerned about recently are these local ordinances that punish businesses, for example, well, some of the ordinances go quite far, and they actually, on their face, would punish a hotel owner for renting a room to an illegal alien, or punish a school for allowing an illegal alien to study there. And we think that there are a lot of constitutional problems with some of those local ordinances, and our immigration lawyers are working on that issue. The other thing that they've been working on, and I think they were working on this long before 9/11, are process issues. So whatever you think about, the immigration laws or the inadmissibility laws, and obviously people have very strong views about whether those inadmissibility laws are too broad or too narrow. But whatever you think about them, there's a separate set of issues that has to do with giving people an opportunity to contest their detention or the immigration charges that are made against them. So if the government comes to you and says, we believe that you are here illegally for these reasons, there's a legal question about what rights do you have to contest that charge. And if the government puts you in detention in relation to immigration charges, there are legal questions about what that detention looks like and what procedural rights you have to challenge that detention. So those are relatively technical questions that are not susceptible to kind of soundbite summary, but they are important constitutional questions that our immigration lawyers have seen as important, I think, for many, many years. There's this is the only specific case I'll mention, but there's a case out of the Supreme Court called Zedvitas or Zedvitas, which involves a question whether the government can continue to detain somebody whom it's detained pending deportation if it becomes clear that the person can't be deported. And that comes up quite often because there are countries that refuse to accept their their nationals back, or there are countries that we can't send people back to because they will be tortured there. So there are these situations where people are sitting in detention inside the United States, not because they violated any criminal law, but because they were found to be here illegally. But they've been in detention for a very long time, pending deportation, that everybody now agrees will never take place. So the question is, can these people have an opportunity to challenge that detention? Can they be held forever? Or is there a point at which the government has to let them go, barring some actual identifiable risk to security? Yeah?
Who exactly does the ACLU work with? Like, does it work more with the government? Does it work more with just people in general, organizations, companies, etc.?
Mm-hmm. Well, it depends what we're working on. So what I work on is litigation. So we always have a client in litigation. The client could be someone like Khalid al-Masri, whom I mentioned, or it could be a big organization. We represent Human Rights Watch in one of our cases. We represent PEN American Center, which is the Writers Guild in another case. And we work with we work with clients or institutional or organizations that have a complaint of a constitutional dimension. So if there's a federal statute that somebody believes is unconstitutional, we might consider representing them in a challenge to that statute. When it comes to lobbying Congress, we work with all sorts of people and organizations. We try to work with organizations from across the political spectrum, not because we are particularly open-minded people. We're no more open-minded than anyone else, but we work with people who agree with us and we try to be effective, and sometimes the people who agree with us and will make us most effective are people who disagree with us on 99% of the issues but agree with us on this one particular thing. And for that reason, we did a lot of work against the Patriot Act, for example, with the American Conservative Union, which had very strong feelings about government surveillance and individual privacy. And we've worked with some religious organizations on immigration reform. And we've worked with some humanitarian organizations in challenges to some of the Patriot Act provisions that end up restricting the work of humanitarian organizations overseas. So it depends on the issue we're working on, but we try to work with organizations from across the spectrum because it makes us most effective. Yes?
How is the ACLU funded, and in terms of your clients, what's the referral process?
We're funded entirely by private donations, and many of those come from individual donors. Some of them come from foundations like the Ford Foundation or MacArthur or Open Society. But most of our money comes from members and donations from individuals. We don't charge for our legal services, so when we represent somebody in court, we never send them a bill for our legal fees. It's always done for free. Partly because we don't charge for our legal services, we get a lot of requests for legal representation. We try to bring cases that have an impact beyond the individual case. So, for example, the Khalid al-Masri case we brought because we saw that there was this whole program of CIA renditions to countries that are known to use torture. We thought that by bringing that particular case, we might have an effect on the entire program. It's true of our Patriot Act challenges as well. We challenge these provisions not necessarily because we believe that they've been applied unjustly in the specific case that we're bringing, although that's often true. But we challenge them because if we prevail in that challenge, it'll have an effect on many other people who aren't before the court. I mean, the term of art for it amongst the legal community is impact litigation. We try to bring impact litigation, lawsuits that have an effect beyond the parties who are before the court. Any other questions? Yes?
I have one other question. Are the majority of the people that work in the ACLU, are they mostly law students, or do they go to law school?
I don't know about the majority. All of the litigators are obviously people who went to law school, but litigators are maybe a third of the organization. And then we have many other professionals who work at the organization. Some of them do communications work, some of them do advocacy that's non-litigation advocacy. And then we have a development staff. So there are a lot of people, and then there's a whole bunch of there's a whole slew of people who are who support the litigation, but who aren't lawyers themselves, legal assistants and paralegals. So I don't know about the exact proportions, but the people who argue in court and who file the briefs are lawyers. That's about a third of the people, but the rest aren't. Yeah. Do you have a question too?
Yeah, you mentioned that sometimes you go into a case knowing more or less that you're going to lose, yet you also seek out cases that can impact more than just one individual. How do you weigh, for example, your likelihood of losing an important case with the fact that you might set a precedent against yourself and spend hours working in effect against your cause?
Yeah, that's a good question. I mean, the truth is, I don't think we've ever brought a case that we knew we would lose. Okay. We always, it's no fun to bring a case that you know you're going to lose. But we have brought cases that we think of as very difficult to win. And one of the things we weigh in bringing those cases is the danger of setting a bad precedent. But these legal precedents in the end are just writing in a book, and weighed against that is a real person who was in CIA custody, or who was discriminated against, or who was denied a visa that they were entitled to, or was fired from a job in a way that suggests that they were being retaliated against for their speech or something like that. So, while we do take into account that there's a danger of creating bad legal precedent, it's often difficult to let that outweigh the particular client or the particular set of issues that are presented in the case. Yes?
Jameel, could you say a word about the origins of the ACLU, and also has the mission of the ACLU remained consistent over time?
Yeah, well, the ACLU is, I guess, almost 90 years old now. It was founded during the First World War, and it was founded in part because Russians and anarchists were being rounded up in the way that Japanese citizens were being rounded up in World War II, and in the way that Muslims were being rounded up over the last few years. And so it was a reaction in part to law enforcement and intelligence activities that were disproportionately focused on particular communities, and also on the stifling of dissent during wartime. And I think that for many years the ACLU was justifiably thought of as a free speech organization. And it still is a free speech organization, but I think that its mandate is much broader now than it was, say, 30 years ago. 30 years ago, the ACLU was known for the Skokie case, in which we represented neo-Nazis who wanted to walk through a neighborhood of Holocaust survivors, and they wanted to march through that neighborhood. And for obvious reasons, people thought that was a bad idea, and they thought that that kind of speech would be inflammatory, incendiary. And we agreed with all of that, but I say we, but I wasn't at the ACLU then. But we nonetheless represented the people who wanted to march. And that was a very controversial case, something that was very difficult for the ACLU. It was led by somebody whose parents were killed during the Holocaust at that time. R.A. Nair was the executive director of the ACLU when we represented the neo-Nazis in that case. But you know, at that time, the ACLU was known as a free speech organization. That was the kind of work it was known for. I think now the ACLU has a much broader. We now are organized into a whole set of projects. One of which is free speech, but I direct the National Security Project. There's also an Immigrants' Rights Project. There's a Women's Rights Project. There's a Reproductive Freedom Project. So there are all sorts of different constitutional issues that the ACLU now has a stake in, whereas 20 or 30 years ago it was almost entirely free speech. Now that sometimes makes for interesting water cooler conversations at the ACLU, because obviously sometimes there are tensions or conflicts between these various values. But you know, the ACLU has grown, and as it's grown, it's changed in that way. Yeah.
A lot of other nations, like Canada and many European countries, have statutes that prohibit hate speech and things like that. Given that the U.S. already does not protect fighting words, do you see a need for any prohibition against hate speech in the U.S., or are you satisfied with the First Amendment in that regard?
Right. No, I mean, we don't support a hate speech law here. That's not because we don't think there's hate speech. There's lots of speech out there that's hateful, and that I would rather didn't take place at all. But the basic theory is that the cure would be worse than the disease. That any hate speech law would stifle expression that really does have value to society, and that the best response to bad speech is good speech, and that the way to confront that kind of hate, which again, you know, nobody denies exists, is to confront it with more words rather than a law prohibiting it. And I think that if you look at the way that hate speech laws have been applied in other countries, I think that it becomes clear very quickly how easily those laws can be abused to stifle speech that, while controversial, is not actually meant to incite hate about anyone. And I think that's one area where the ACLU's position has remained the same since the organization was founded. Yeah.
Okay. How can, like, us as a public get more involved with, like, the policies that you guys that ACLU is supporting, or like find more information about it?
Mm-hmm. Well, we have a website that on good days is useful. There's a lot of information on the website about the issues that we're working on, and about what individuals can do to support change on those issues. We actually have a whole set of people now in Washington that send out action alerts on a nearly weekly basis, trying to get people to focus their activities around particular legislators or around particular legislation. And the idea is to pick the areas where we really feel like we can make change quickly, and to get people to call those legislators or support that legislation, or in some cases write letters to the editor of a particular newspaper or on a particular topic. So we do have that. We do have that team of people working on those things. And if you go to our website, which is aclu.org, you can sign up for those action alerts, and that's a good way to get into that process. Yes.
I was just curious if you have any collaboration or crossing of paths with the Southern Poverty Law Center.
Yeah, I don't personally, but I know that that if I'm thinking of the right organization, it's an organization that our Racial Justice Project has worked with before, but I've never worked with them myself.
As teachers, we're very much involved with that. We get the Teaching Tolerance magazine.
Right.
Just more with the schools, but just wondered if the paths ever crossed.
Yeah, I mean, definitely the paths, the ACLU's path has crossed with that organization's path, but my own hasn't. Yes?
I don't even know what question I want to ask, except I want to know how your experience with these cases that you've related tonight, how your personal feelings have progressed. Have you felt yourself changing as they brought you to a different place in your life than you expected to be? I don't know.
Well, I'm definitely at a different place in life than I expected to be. I mean, when I graduated from law school, I was expecting to be a corporate lawyer, and I certainly make less money than I would if I were a corporate lawyer. But you know, I think that it happens to a lot of people who end up at organizations like the ACLU. You start doing it thinking that you'll do it in your spare time, and the work that you're doing in your spare time turns out to be more fulfilling than the work that you were doing in your day job. And so you think, well, I'll do it for a year or two and then I'll go back. But you know, once you work on these cases, you know, you feel like, you know, even on cases where we clearly lost, and there were a lot of cases that, you know, that we've lost over the last 8 years, I always felt like, you know, I was doing what I could on those issues that I cared about, and that's something that always bothered me when I was a corporate lawyer. I wake up in the morning and read the editorial page or read the front page of the newspaper. And there were all these issues that I thought that I would like to be engaged with, or that I thought should be worked out differently than they were actually being worked out, and I just felt I felt like I couldn't do anything about them. And at the ACLU, at least I feel like, you know, I'm using whatever limited resources and talents I have to make a difference on those issues. And sometimes it's not much of a difference at all, but it nonetheless means something to me to be trying to do something about it. And so I found it such a fulfilling career, such a rewarding time to be at the organization, and just so many people at that organization, you know, really do want to make things better on these issues. And you know, I'm sure that there are people at organizations that have exactly the opposite views of the ACLU, who feel exactly the same way about the work they do. But it doesn't change the way that I feel about my own job, or the way that I think my colleagues feel about their jobs. And it's rare to find a legal organization at which so many people are happy with the work that they're doing. You know, I think maybe impossible to find another organization where there's so many happy lawyers. But you know, the ACLU is a place where people really do feel like, you know, they feel like they're doing the work that they want to do, and that they're given a chance to, you know, make a difference on some of the issues that they care about. Yes?
With the changes that have been made in the first 40 to 50 days of the new administration, are you kind of hopeful that accountability, and however you like to define that, is going to be had for particularly the officials who are conducting all these tortures, who made all these decisions to do that?
Yeah. Well, you know, one of the things that we spend a lot of time talking about these days at the ACLU is what accountability should look like, and you know, one of the, I guess, over the last month, President Obama, as I said earlier, has already made some decisions that will shut down some of the programs we were most concerned about, and that's great. You know, it's a different world from where we were living, you know, 3 months ago, and from my perspective, that's a really good thing. But when it's come to issues of accountability, President Obama has not been exactly where we wanted him to be. When it comes to, we have a case out in California right now, brought on behalf of 5 people who were victims of the CIA's rendition program. And this is a case in which we're suing not the government, but a corporation called the Jepsen Corporation, which is a corporation that facilitated the CIA's rendition program. They basically ran the flights for the CIA's rendition program. And we allege that they ran these flights knowing full well that the flights were being used to take people to countries where they would be tortured. And the government came into that case and argued that argued that the state secrets privilege foreclosed the case from going forward. And there was a hearing before the appeals court just a couple of weeks ago after the new administration took over. And we were very hopeful that the new administration would drop that state secrets claim. Because we think that that state secrets claim is being used not to protect information that is truly secret, but rather to protect officials from accountability for their conduct. But the new administration ended up essentially signing on to the brief that the Bush administration had filed. And so, on issues like that, on issues relating to accountability for the abuse of the last 8 years, thus far, I can't say that I'm entirely happy with the positions that the new administration has taken. Now, it's very early, and the new administration may yet change its views on, on what kind of accountability they're willing to see happen. But the early signs have not been entirely promising.
Jameel,
All right.
thank you so much.
Thank you.